interested in your preliminary response to the excluded evidence that you touched on after having been told not to do it, or having been told that I was confirming my prior rulings.
I do want to just point out right now, we've got it on the screen. This is a Washington Post article, and there's a reference to an interview that he says, the defendant says, he did not regret having his gun because, quote, I would have died that night if I didn't, end quote. So that's a direct quote from the defendant to the media about that night.
What about that?
Your Honor, all I can say about that interview is there were prior counsel representing him.
I don't care about that.
Well, and I believe it was a telephone interview. I don't know anything about the circumstances of that. I'd have to read the article.
Well, that might make a difference. And what about the, you're asking questions about excluded evidence?
Your Honor, we went over this earlier, and I don't want to repeat myself because I know you've heard me, but if I could just summarize. I did hear you talk about that evidence this morning before testimony. The defendant then took the stand. He admitted that he had said to the person in the yellow pants that he had pointed the gun at that person. I have seen that video. It was actually introduced by the defense. I think it was even in their opening statement. And there's this person who confronts the defendant and accuses him of this. Frankly, to be honest, Your Honor, when I watched the video the first time, I didn't hear the defendant's reaction. I thought it was someone making an accusation and then the defendant walking away as if trying to avoid a confrontation. I was surprised to hear the defendant admit in his testimony, on direct, by his attorney, that yes, I did tell that person that I had pointed the gun at them. He explained then that he was joking when he said that. The jury can evaluate that. It goes to his credibility, it goes to whether or not he's telling the truth, it goes to his decision making. That is, again, this is an incident that occurred that night, so it's not something that happened separate in time. It presumably happened a few minutes before. But like I said, I was taken aback by the defendant admitting that he had said to this person, yes, I pointed a gun at you. And I think it's fair to say that watching that video, that person, believes strongly that this happened. The defendant is telling him it happened. Now the defendant today is giving us a different version and saying, oh, I made it, I was joking, I was just kidding that guy or whatever. I'd like to probe that. I'd like to probe what he said to that person. I'd like to probe what his motivations were, etc. I'd like to probe whether, in fact, he really did do that. And I think that that changes the equation with regard to the CDS video that was the subject of the other act's motion. Because in my mind, it is very similar. And I know we've disagreed on that, and I'm not going to belabor the point, Your Honor, but that was where I was coming from, was there's been a change in the testimony of the defendant today that I think makes that evidence, it's admissible and much more relevant than it already was, and I thought it was already relevant. And the court is, I do want to be clear
So
also.
I'm just here on the sidelines, just
Well, you.
yeah, I had made a ruling that the evidence wasn't coming in, and you decided that it was.
If I could just respond to that briefly, Your Honor, I was about to say, I did not interpret your ruling as an absolute. We've had 3 state motions in the line. There was one in which we asked the court to introduce evidence that the defendant was at Pudgy's bar with Proud Boys, and you were clear, that is not coming in. There was.
Don't get into other subjects. Come on, what you're telling me, you're an experienced trial attorney, and you're telling me that when the judge says, I'm excluding this, you just take it upon yourself to put it in because you think that you've found a way around it? Come on.
If I may finish, Your Honor, I was about to say that your ruling on our 3 motions and other acts motions was there were some gradations there. That you were clear that some things were absolutely out, and then you left the door open on other things. So I saw that distinction, and I thought to myself, clearly I know this is out, but you left the door open on other things. So I didn't interpret your ruling as this is absolutely never coming in, and I have practiced before you, Your Honor. I have filed other motions before you. Your practice oftentimes is to reserve ruling on those until you see the evidence. And I think you even said something to that effect at our motion hearing.
Undoubtedly did.
So I thought, this is my good faith explanation to you, and if you want to yell at me, you can. My good faith feeling this morning after watching that testimony was you had left the door open a little bit, now we had something new, and I was going to probe it.
I don't believe you. There better not be another incident. I'll take the motion under advisement. And you can respond. When you say that you were acting in good faith, I don't believe that, okay? Let's proceed. Everybody in good faith. All right. Would you come up, please, Mr. Rittenhouse?
I do have,
Yeah.
Your Honor,
Yeah.
I do have another item that I want to raise before the jury comes in and raise it with you. There was an other acts motion with regard to the defendant being at Pudgy's Bar after a court appearance in January in which he poses for selfies wearing a shirt that says "free as fuck." I would like to ask the defendant if he posed for selfies after a court appearance with members of the public wearing that shirt. I do not intend to talk about who those people were, what groups they were affiliated with, or anything along those lines. But I believe that it is relevant when the defendant goes to a bar after a court appearance and poses for selfies wearing a shirt like that. I think it is relevant to some of the issues that have come up in this case. For example, his remorse or lack of remorse, his utter disregard for human life. Those are things that I think it comes into play because I think that behavior is not consistent with someone who has a regard for human life. The jury has already watched him break down on the stand with emotion. I'd like to probe how heartfelt and sincere these emotions are when you go to a bar and you pose for selfies with people, when you're out on bond in a first-degree intentional homicide trial wearing a "free as fuck" shirt. So, as I said, I want to use the photograph. I'm not going to talk about any of the people or who they were from. In fact, the photograph I'm going to use has actually got their faces blocked out, so we won't see any of the people in the crowd. We'll just see the defendant standing with a group of people for a selfie with that shirt on. That's as far as I want to go.
Handle this issue.
Nobody got an opportunity. First of all, you've made a ruling on it, and it was clear prior to him testifying. So part of this is, would we have raised it? Would we have brought it up if we would have known that it was going to be coming in? We have done there's been nothing to open this door, Judge. Nothing that has been said to open the door about what happened 4 months after this is relevant in any way to what happened that evening. That is part of what the court had ruled. You had said 4 months after, I don't see how that goes to any 90404 type of admissible evidence. So my argument is, A, you ruled on it previous to him testifying. You confirmed your ruling, which you had made previously, where Mr. Binger just said you had shut the door on it. So apparently he doesn't believe a door that is shut should stay shut. However, now he's asking that something be admitted that, to be fair, this should have been brought up sooner. This jury, I did the voir dire, I would have voir dired on an issue of whether or not they heard it, saw it, were aware of it, how they felt about it, whether it had an impact on their ability to be fair in the case. We never went there because of your prior ruling. So there's nothing that's opened this door, and I don't think it's relevant, something that happened 4 months later. He talks about indifference to human life. That's that night, not 4 months later. There's nothing that's relevant about that. You've already made your ruling. I ask that you stick with it.
I'm struggling with why it would be relevant to any of the issues in this case. If he were on trial for using exquisitely bad judgment, if he were on trial for behaving in a very offensive way, then I could see the purpose. But an incident that occurred 4 months after the incidents in question, I don't see how that jury can work with that in reaching any conclusions about the issues in this case.
First of all, Your Honor, we have introduced evidence that the defendant had a slogan on his TikTok page, "Bro, I'm just trying to be famous." This case has made him famous, and he's posing for selfies as a result. One of our theories of this case is that his behavior that night was intended to gain attention, to be famous, and he's reaped the benefits of that. Second of all, he is on trial, in my opinion, for exquisitely poor decision-making. Taking a gun that he's not legally entitled to have, coming down in violation of curfew, running around the community with that gun, trying to be a police officer when he's not, confronting protesters that he knows are hostile, and all of those behaviors, I think, are exquisitely bad judgment. So the jury can make that decision. The jury can give what weight they want to this evidence, but it's moments after he has a court appearance here. He's out on bond in this case when he decides to do this behavior, and nobody made him do it. Nobody forced him to go to the bar. Nobody forced him to wear the shirt. Nobody forced him to pose for selfies. It's his own decision making. And
When
think-
when I made reference to exquisitely poor judgment, I was talking about at the incident when he was wearing the shirt. Because, everybody in all of humanity, at one time or another, displays bad judgment, sometimes exquisitely bad judgment. And we don't let it into people's trials on unrelated matters. So I wasn't referring to his having had good or bad judgment on the day in question. That's a legitimate inquiry, and you're being allowed to present a lot of evidence on that subject. And the jury is going to be instructed in some of the element of some of the crimes that are charged here is going to deal with the caliber of his judgment. But you're talking about an incident that occurred 4 months later. So I'm not seeing it, and I don't want to waste any more time with it. I don't think that, I've ruled before, it's not admissible, and I have heard nothing to change my mind about that.
It was sought to be admitted earlier for a different purpose, Your Honor.
I'm sorry.
It was sought to be admitted earlier for a different purpose than it is today. The court has ruled that it can't be admitted for the prior purpose, but I am seeking to introduce it for a different purpose today.
And that request is denied.
Thank you.
Okay? Are we ready to go? All right, good afternoon, folks, and I've sustained the objection to the last, so let's proceed.
Good afternoon, Mr. Rittenhouse.
Good afternoon.
You testified earlier that there were times that evening when Mr. Rosenbaum had threatened you. Is that right?
Yes.
And you described him as wearing a red shirt with a blue bandana. Is that correct?
At certain times.
Yeah. When he threatened you, that's what he was wearing?
I believe the first time he threatened me, he was wearing a red shirt with the blue bandana. The second time, he had it wrapped around his face.
Had what wrapped around his face?
His T-shirt.
So he wasn't wearing a shirt the second time around.
Correct.
And you indicated at one point you thought he had a chain in his hand?
I believe so.
When he made the threat to you with the red shirt on and the blue bandana, did he have the chain in his hand?
I think one of the times he did.
Okay, and so which of the times was it?
I can't recall off the top of my head. I think it was the time when he was threatening to cut people's hearts out.
And I don't need to know the threat, I just need to know which time it was. Was it the first time or the second time?
Second time, the second time.
What was he wearing the second time?
He was masked. Well, the shirt wrapped around his face.
And he didn't have a shirt on his torso.
Correct.
And you could see when he didn't have a shirt on his torso that he didn't have any gun tucked in his waistband, correct?
I wasn't paying attention to that. I was behind Joanne Fiedler. I was somewhere over there.
So how far away were you from Mr. Rosenbaum when he made the second threat?
By 10, 15 feet, I'm not really certain.
But you were close enough to hear the words out of his mouth.
Yes.
And you took that as a threat to you personally?
I took the first one where he said, if I catch you alone, I'm going to kill you. I took that as a threat to me personally. The second time, I took that as a threat to the group.
Can we have that photo, Exhibit 138 up on the screen, please?